My name is Edwin Faru Muriuki. I am a partner at Bowmans, Kenya, a law firm. We are a full service law firm, but I am a partner in the projects, energy and infrastructure space, and I'm glad to be here. Excuse my my weird voice. I'm recovering from a bit of a flu, but I think we will manage. So I'll invite my panelists to to take their seats at the front, please. I want to introduce them when they are here so that you can know who I'm referring to and they can wave. Please give them a clap. Please give them a clap as they come to the front. So when it comes to captive power projects, I think the technology has been proven, it's there. We are now heading almost to standardization. So projects generally don't struggle from a technology perspective. It is the implementation. Usually you call your technical advisor, they do the studies, you have a system, a technical solution that works for you. You have your finance people sit in a room and they come out with a number that works for you. And then the lawyers show up and everything goes crazy. So what we are trying to discuss and what our panelists here will help us unbundle is the legal, tax, and compliance considerations for captive power projects. To introduce my panel, I'll start with the ladies. I have Cindy Oraro. Cindy Oraro, wave to everyone. Cindy Oraro is a partner at Oraro and Company Advocates. She specializes in energy infrastructure and projects. She has over 14 years of experience and she advises lenders, sponsors, and financiers on complex cross-border transactions. Clap for Cindy, please. On my far right, I have Lucy Ocharo. Lucy is legal counsel at EED Advisory. She's also an advocate of the High Court of Kenya with over 8 years experience in cross-border M&A, fund governance, and regulatory strategy. She leads the ESG function for Africa-focused energy funds and has worked on a 21-country environmental and social regulatory mapping study for CEI Africa Fund. We'll be drawing on her cross-border experience and her knowledge on compliance matters. A clap for Lucy, please. To the gentleman, CS Ibrahim Kitoo, who I'm sure does not need introduction to most of you. CS Ibrahim Kitoo is the Corporation Secretary and General Counsel at EPRA, where he leads the legal, regulatory, governance, and commercial functions. He's also an advocate of the High Court of Kenya, a certified PPP practitioner with over 15 years experience in the energy sector, infrastructure finance, and public sector advisory. A clap for CS Kitoo. And finally, I have my namesake, Edwin Ngatia. Edwin is a commercial leader in the distributed energy sector, working with commercial and industrial clients to shape and deliver large-scale energy solutions. His experience spans structuring and commercialization of energy projects with a focus on aligning investor requirements, client priorities, and most importantly, market realities. A clap for Edwin as we start the session. So I think just the way we've sat in this order, I'll start with you, Bwana CS. My first question to you is, from a regulatory perspective, I know you sit at EPRA, what are the compliance and regulatory requirements for these captive power projects?
Yeah, thank you. Thank you, Edwin. And of course, I will wish to welcome everybody into this session as well. Yeah, firstly, let me clarify that lawyers should not show up. They should be there when the game is starting. And that is how you make projects work. Speaking from or drawing from experience, for the time I was in Kengen and taking care of projects for 8 years. So lawyers should be at the forefront, even at the point of initiating the project. So Edwin, to that extent, then I think we need to have some shift. So in terms of the regulatory framework, in terms of captive power projects, of course, a typical thing is that as a regulator, we don't ask for much. Our role number one is to facilitate the sector, because as government and as an enabler to the government's obligation to ensure sustainable, affordable, and of course safe electricity to the country, we need to make sure that we create an environment which is facilitative. So in terms of the needs, of course, there are the obvious things we'll be looking at. Those are the registration requirements, like a certificate of incorporations. We'll be looking at things speaking to, the title deeds, or leases pertaining to where the project is to be done. We're also looking at things to do with the technical reports about the technical feasibility of the projects. The other things we are also very keen, especially in cases whereby captive power speaks to sell, you'll be looking at you being able to demonstrate that you have a power purchase agreement in place. And then, of course, very important is for you to be able to demonstrate that you've also been able to comply with the National Environment Management Authority, compliance expectations by NEMA. So NEMA license is equally required. Well, some of the few, but the main things we look at in terms of regulating and of course regulatory requirements for you to get certificate to venture into captive power business.
I think just to expound on that discussion, for captive power projects, we of course have the infamous 1 megawatt threshold for own use exemption. Could you just explain that a bit more? And I know most of the people here who are in the space, the general view, and I might be wrong, and maybe I'll get Cindy to speak more to that. The general view is that megawatt threshold is a bit low. What is EPRA's view around this? How are you thinking about it? And maybe Cindy will also talk about then how that has affected the development of projects.
Okay. Edwin, one of the things I may need to clarify is that we need to trace back to when the Act was actually enacted. That was 2019. And of course, right now we are talking of 2025. Eh? So a lot of time has actually passed from the time the Act was enacted. And remember, before you even enact the Act, there were so many discussions tracing back to almost 3 years. Eh? So the 1 megawatt you are seeing, you should not see it in light of today. You should actually trace it back to 2019 minus 3, that's 2016. So we are talking about a lag period of 10 years. So certainly the 1 megawatt of 10 years is not the same as the 1 megawatt of today. Trying to trace the needs and of course the increased appetite for C&I as we speak, and the increased need for power in the sector. And of course trying to benchmark with other countries. Certainly the 1 megawatt looks like it's an area we need to speak to review, because I will tell you that if you are able to do benchmarks with other countries, Brazil and the sort, actually 1 megawatt is too small. But then of course looking at Kenya and in our own special circumstances, we may not need to align the 1 megawatt to those other economies like Brazil, Europe and the sort, but we need to have realities speaking to our current needs. So certainly that's an area we are looking into, and especially as a possible area to enhance. But typical of our discipline as a regulator is that we are keen to subject that to, of course, public participation to stakeholders, so that then we can come up with a number which looks factual and it's realistic, and a number which can also remain a little bit stable for some long haul before we before we start now talking about changing from whichever megawatts we'll be thinking about to another. So it's an area we are keen to look and holistically. Yeah. But we may also need to draw from the experience that during that time, I think there is this one question we cannot run away with, that in a case whereby you have contracts which have already been signed, PPAs which have been signed, and you have a player in place, and in this case, I think they are speaking about Kenya Power, which has been, the dominant off-taker for quite some time. There's also an aspect to think about sustaining the sector, appreciating that Kenya Power also had some commitments. So sometimes for you to sustain the sector, it's good that you don't open it up so much to an extent that you kill, the off-taker. So I think that was also a thinking in mind that time. And I think maybe time has changed, and that may not be purely a thinking we need to take into consideration solely as we move forward.
Yeah, I think that's a good point. We are in the age where we are talking about open access, which will be one of the things we are discussing. So, Cindy, I don't know if you have anything to add to that point.
All right. Thank you. Yeah, so this is a very, very controversial point because, as many of you know, a captive power is mostly used by C&I, right? So if you have a factory, you're a manufacturer, if you are a flower farm, you need more than just 1 megawatt, right? You're looking at maybe 5, 10, 20 megawatts, right? And you don't want to classify yourself as the likes of KenGen, because you see the generation license is meant to kind of protect the grid. There are a number of parameters that Ibrahim here and his colleagues look at. So as a captive power project for own use, quote unquote, you do not pose the same risks as an IPP, as KenGen, as a large power producer. So why should you go through the same licensing process to get the power that you need for your own operations, right? So with that in mind, I foresee, just like is the case with other jurisdictions, that limit going up, perhaps to 5 or 10 megawatts, which is more feasible for the market. Currently, quite regularly, I see projects being structured to try and fall below that 1 megawatt and then increase it in phases. So that wastes a lot of time and money. And of course, you're doing that for a short period of time because inevitably that floor has to rise. So what I advise clients is we expect this perhaps within the next 3 to 5 years to change. So don't structure a project to fall below the 1 megawatt just to avoid that whole generation license process, right? Build your projects to scale and make sure the entire project document suite, your PPA, your land lease, factors that in. Otherwise, you're going to have to renegotiate all your projects from scratch.
Thank you, Cindy. I think you're better than I am. I am happy to advise clients on how to structure projects for the fees so that they fall below that threshold. But that's on a light note. Edwin, I think we'll put a pin on that discussion and move to you. For this captive power projects, you have a lot of experience in structuring solutions for end users and for sponsors. What are the key structures that you've seen in the market? What drives the choice of structure? And if you can give us some more insights on what trends you're seeing in that space in terms of structuring.
Okay, thank you, Edwin. So first of all, obviously we have the PPA, which we have learned from Penina is now the power plant agreement as opposed to the power purchase. But we have the PPA. Obviously, the power purchase agreement is an arrangement by which the off-taker becomes your client for an extended period, 10, 15, 20 years, by which you sell them electricity at a pre-agreed tariff, oftentimes with an escalation ranging between 2 and 3% for a long duration. What usually determines whether somebody will take a PPA is, number one, if they're bankable. Nobody's going to put their money behind a project if they have a fear that their money is not going to come back or that the entity is not going to be around for the duration of the contract. A 20-year engagement obviously is a marriage of sorts. So you have to make sure that the person you're getting into this engagement with is somebody who's going to be there for the foreseeable future. Over and above that, we have what we call the lease, the solar lease. Solar leases tend to have a slightly shorter duration, 5 to 10 years, which is, we are seeing a trend towards that, Edwin. Speaking of trends, we are seeing a trend of clients not wanting to get into such long-term engagements. So the solar lease is becoming increasingly popular. And just to mention on the PPA operates off balance sheet, which is different from how the solar lease operates. So you'll have entities that are looking for relatively short-term engagements. It tends to be structured more as a monthly payment, fixed monthly payment over the duration of the contract, as opposed to an electricity-based tariff. Although there is a way that you can, if you know the number of units that are going to be generated by the solar system and you know how much you want to charge on a monthly basis, there's a way you can structure it such that it actually does look like a tariff of sorts. And obviously the last one would be the outright purchase model, which is usually for well-capitalized companies. They have the finances to do the project. So for them, it is just somebody who wants to avoid sometimes the counterparty risk. If you don't want to get into a relationship with these and other companies for an extended period, you could purchase the system yourself and enjoy the benefits from day one. Obviously, the savings are going to be best when you purchase the system from day one. And that's one of the reasons that people choose to go to that direction. Now, as regards the question on trends, what we are seeing now with the trends from a commercial lens is that a lot of the clients are a lot more knowledgeable on what is available to them on the market. It is not like a few years ago where you'd meet a client and the first thing you have to do is convince them that solar is capable of powering anything more than the radio of their father in the village, which is how things were a few years ago for any one of us who was operating with 2019, 2020. The market is fully mature. It is no longer a discussion of whether solar is going to make you savings. It's more a discussion of who can get me the best savings. So we are seeing a trend towards a very knowledgeable end user, very knowledgeable client who is going to dig deep into your proposal. The other things we're seeing, I think I had maybe mentioned this, Edwin, slightly, is that we are seeing people wanting shorter duration contracts. Nobody wants to get into the 20-year PPAs, fortunately and unfortunately. And I can give you an example of when we saw this best. During the finance bill that preceded the quote-unquote maandamano, one of the proposals was to have an eco-levy on plastics and plastics manufacturers. What that did is that introduced a level of fear in a lot of the entities that existed. And by virtue of that, they didn't want to get into any long-term engagements. So how we had to, as a market, shift our thinking is shorter-term contracts to fix that fear, existential fear of engaging in anything that looks like a liability. So shorter-term engagements is something else that we've seen. And the third one, as I close, is on storage. A lot of the conversations you're going to have nowadays with potential clients, there's always going to be the question of storage. Are we going to do a battery for this system? Obviously, that has price implications, either as an outright purchase or as a PPA, because obviously CapEx going into the financial model results in a higher tariff. But storage is increasingly becoming a conversation in which clients want to engage. And this is existing clients and clients that are putting up their factories, their facilities, their hotels now. Should we buy a diesel generator at all? Or can we bypass that for storage and for backup and go straight to solar plus battery? Thank you.
Yeah, that's quite insightful. It's a buyer's market. Contracts are becoming shorter term, and storage is on the rise, which then segues quite well into questions around structuring of these arrangements. What is bankable, as you mentioned, and what is not? So maybe, Cindy, you could speak to that. What have you seen as being critical in terms of these projects moving from term sheet to actual agreements that are signed? What are the critical risk allocation decisions that parties make that determines whether the thing gets signed or it gets financed?
All right. Thanks, Edwin. That's a very pertinent question. So when you have a term sheet, all that means is that you have commercial alignment. And as many of you know, bankability basically means that financiers have agreed to fund a security package that just so happens to be backed by a project. So I think one of the key things that we are seeing happen in our market, unfortunately, is because the PPA is so important, people rush and sign a PPA before securing their land rights. And as we know, most of these projects are on community land. we've seen cases where the project cannot proceed because of issues that have arisen at that level. Number one, it could be that lease restrictions and renegotiating that. Say you have to amend a head lease. So in one particular case, I've seen a project delayed for over 2 years because of that. Another critical thing is that community land rights cannot be ignored. The process by which you get community consent must be followed. Otherwise, it's not voidable, it's completely void. You cannot proceed with your project. So that's another thing to consider. And lenders are now critically looking at those factors. Another thing which I'm sure we'll come to, and Edwin here on my right, on my left will deal with it, is tax and tax implications. Because in the recent past, we have seen changes in the tax regime significantly increasing project costs. So those are some of the critical issues that could affect bankability down the line, but that is where we lawyers come in, right? So we should be able to draft agreements that would protect and factor in some of those contingencies. I would give an example of change in law, which we will come to. If, for example, we're dealing with, say, the capped standard levy, if I can touch on that in brief, where a new levy is introduced. Previously, it was only 0.2% of CIF. Now it's 2%, a tenfold increase. Then, of course, the developer would bear this cost tenfold. How do you factor that in? And, of course, a good lender, well, most of them will catch this, right? Those are some of the critical issues that could affect bankability.
Yeah, I think. Hi, Lucy. Hi, I haven't forgotten about you.
No, I know.
Yes, so I think let me put a pin on the points that we were just discussing here around tax and bankability. Actually, let me just bring you in on bankability. Yeah? From your perspective and your experience from compliance and ESG aspects of this kind of power projects, what do you look at to say that this project is something that we are interested in or you should be interested in? What makes this project scalable from an ESG perspective?
Thanks for the question, Edwin. So to answer that question, I'll start by identifying some of the E and S factors that we look at. So under environment, it's things like emissions. Think of things like water usage, access to the environment where you're going to be setting up the project, and the environmental, social impact assessments. When you talk about social, think about the community consent and land use that Cindy was talking about. Also on the environment, there's things like e-waste management. So when it comes to assessing the bankability of a project, you're essentially analyzing the risks under these different factors that So when it comes to E&S risks assessment, specifically under essentially looking at whether a project is bankable, you're looking at the proposed project and how it affects each of the different factors, and how you determine the factors that would potentially be affected will differ from one project to the other depending on where the financing is being sourced. And that's why you'll find there are finances that this financing that you can access from someone who's keen on biodiversity and cultural protection. So which means they will be closely looking at your land use and obtaining consent from the local community. Then you'll find someone else who's providing financing for e-waste. And I was happy to hear Romano in the morning talking about a couple of projects, and also SEREC, because we work with them on some of those e-waste management activities. So depending on where the financing is coming from, to determine how and whether that project is bankable, the different risks are looked at under E, and E being environment, and under social, and that then determines whether a finance is available to finance, and at times also whether you're compliant with both host country laws and international standards.
So from your perspective, looking at ESG, how important are they in how important is ESG in terms of unlocking private capital? What are investors now expecting? There was a time, I think around 2023, ESG was all the rave. I remember at our law firm, we used to have trainings almost every week because we had to learn what ESG was. Clients were asking us what our ESG compliance requirements. I think now with the new Trump administration, ESG is not as a key issue, but you're saying lenders still look at this. What are they looking at? What are they asking for?
Yes. So, and you actually brought back a point I was having at the back of my mind. When we talk about ESG, I think there can be a disconnect between what it actually is and it's sort of the AI bubble. There's this giant bubble that people have about what ESG is and what it actually is. And I'll sort of try and bring it down by giving an example. When you are setting up a project, designing the project, under environment, there are specific things you look at. And these things are divided according to different factors, depending from one market to the other, or where you eventually intend to find financing from. Under social, you will have different factors that you're looking at. So under social, think about labor rights, modern slavery, and all those things. So these things actually exist in law. We have country-level laws and international statutes. An example is the IFC performance standards, your Equator principles, the Basel Convention. So it's not an isolated thing. It's just that to progress, to make sure that projects are being curated in a way that is actually sustainable, then let's closely monitor what these things are. So as an organization, you look at, as an organization or financier, you're looking at, so I am trying to make sure that the carbon emissions get to this point. So I will specifically look at projects that meet this carbon emission abatement, that specifically abate this level of emissions. And I don't know whether I'm answering your question or I'm going on a tangent. Okay. And in certain instances, you'll be able to access green financing by demonstrating that you are having certain ENS performance commitments as a project, which then look good on a financier's books and also help you access financing at a lower rate or a more the word escapes me.
Favorable.
Yes, a more favorable rate.
So thank you very much. I think the ESG points still remain relevant. We are still seeing those schedules on ESG requirements for projects still being insisted upon in financing agreements and in some PPAs actually. So I think let's just go back to the point that we were discussing earlier around taxes and what effect that has on captive power projects, planning, financing, development. Edwin, you had a really good point about the proposed levy that was to come in, and all of a sudden no customer was willing to sign something that was long-term. Everyone was jittery about what the future holds. So maybe you can go into a bit more examples of where there's been positive impact by taxes, incentives that have changed the way the market behaves, what changes in tax have meant for projects, and what that has done to the project economics in projects you've been involved in.
That's a good question. So I think the the zero rating of solar equipment from basically the onset. I think at the stage where I think we discussed that the market is mature now. Before the market was mature, there was the zero rating of VAT products, and it was of solar products, and it was on the larger components, the components that form 50, 60, 70% of a project. That's panels, that's inverters, potentially batteries, but that was a conversation that came later on. And that allowed for the rooting of the culture of solar installations in this market. The fact that that has remained has helped the industry grow, because a 16% increase means that a lot of project IRRs become unsustainable. So that from the onset of the market and the setup of the market has really been a positive in terms of solar adoption. Of course, we had the little blimp in, was it 2020, Kitoo, when we had the VAT returned, but of course that was subsequently removed. Now, Edwin, you asked me about the positives. Unfortunately, as a commercial player, I saw a bit in the negatives. And let me contextualize. With regards to the tax uncertainty that we have experienced, that has, on a commercial, using a commercial lens, it's become difficult to plan when every finance bill is potentially existential for the company. I give the example of the eco levy, and that is on the client side. Developer side, if we have panels potentially going up like they did again in 2020, then you can imagine the amount of uncertainty that breeds within the developers themselves and from potential investors, because not all developers are based here. You have developers coming from France, from the Netherlands. We've had one or two from the UK, deep in and out. We've had some guys from Mauritius, and the market becomes less attractive to them if they can't predict from 1 year to the next how things are going to be, especially if they're looking to make a 20-year play in the market. So unfortunately, Edwin, I feel as though I have taken the conversation in a slightly different direction, but I feel from a commercial standpoint, it's important to have the conversation around tax uncertainty, because that really makes it difficult to plan commercially for the extended period.
So certainty is a key point, and I think we'll come back to Kitoo on the point around policy certainty. Cindy, maybe I could also touch base with you around the same issue. What have we seen from a tax and legal structuring perspective in terms of uncertainties and how that has affected investment decisions in the projects and transactions you've been involved in?
Yeah, so I think I'll start with an analogy, which I'm sure Mr. Kitoo here and Edwin know. Like, a good lawyer is like a tea. We have a depth in one area, but we have a broad section of knowledge in a wide range of areas of expertise. I say this because I'm not a tax lawyer, but I have interacted with these tax structuring issues that arise from project to project. So I'm speaking from my experience. So the first thing is tax structure, like determining the structure of your project. So we've heard that the most common structure here is the PPAs. And it's a structure that everybody knows. So you're not bringing in something like, for example, even if you bring a finance lease or an operating lease, it's not as common in the market. So from a tax perspective, you'd have to understand that you'll be paying 16% VAT on the tariff, month in, month out, right? And that accumulates over time. So the other choice that you have from a VAT perspective is to have a lease. And the lease gives you the option of setting off input VAT, right? So it could be an optimal structure. The problem is that, unfortunately, commercials are agreed before we lawyers and tax experts are consulted. So sometimes there's a lot of scrambling to like put something into place that could be optimal. But now we know not to do that. I mean, by we, I mean all of you, right? And then there's also the energy service as an agreement. So because this is relatively new, it's a gray zone. And it's a gray zone specifically for KRA. So you'd have to show that it is actually a service, and that is based on KRA's discretion, you know. Those of you who have dealt in tax disputes know the pain of going back and forth on this issue and sometimes how it could end, right? So that's one issue to consider. Structuring from tax at the outset, consulting your legal and tax advisor so that you get the optimal structure, and then look at it in view of the life cycle of the project. So it's not just a year, it's 20 years. So if you're paying 16% VAT for 20 years, what is that going to look like to your IRR? So the second issue to consider is depreciation, right? So in East Africa, Kenya has one of the most attractive tax incentives for renewable energy, at least on paper, but we're trying to implement. Yeah, so there's this thing of the 100% first year deduction on plant and machinery. It's not consistent because some plant and machinery you cannot apply the deduction. But as a lawyer, one thing we see blocking clients, blocking industry players from developers and off-takers from benefiting from this is inconsistent documentation. So for example, your PPA could say one thing, your lease says, no, actually your financier is the one who owns the equipment. Your EPC contract says that, the equipment will be transferred to you, on commissioning or something like that. So of course, KRA is looking for evidence that you actually own the equipment and your documents are saying 3, 4, 5 different things. Of course, you're not going to benefit. So having proper legal structuring around these things is the key to unlocking some of those benefits. And then lastly is what we call the import-port surprise. So many, a developer, many an off-taker are sitting in sitting in our offices, having not factored in assessments at the port, right? And let me give you an example. So landed cost, if landed cost is not taken into, your financial structuring, you could find yourself with an idea for 3.5%, rail development levy at 2%, duty and VAT. Imagine you have a 5 megawatt solar C&I captive project. The project is $3 to $4 million. Those taxes alone would be $500,000 if you cumulate them, right? So it's a huge cost. And that's why the issue of legal and tax optimization must be considered very strongly at the outset. It's expensive because it's 2 to 5% of the project cost, but it's totally worth it.
Interesting. I want to sort of buttress that point. I have been in those discussions where parties have structured a document and then there's a discussion a few years on who's supposed to claim the IDA, and the KRA is saying both of you can't claim, no, you are supposed to have done this and this. So it's a real discussion, and it should be had at the outset from the financial structuring and then reflected in the legal documentation. So I think to get us out of this negative sort of vibe that is going on around these things, CS Kitoo, what are you guys doing? What is the regulator, what is the government doing to make, from a legal regulatory compliance perspective, to make these projects comfortable, executable, easier, more sustainable, and profitable for the sector? And you can also take the opportunity to respond to any of the comments from the other panelists.
Yeah, Edwin, let me start by saying that the academic definition of bankability is when you think about it in terms of the ability of a project to attract financing or to have appetite for financing from possible financiers. My understanding of bankability is a little bit more robust in that I look at it with a 360 view. That when you talk about bankability of a project, the first thing you need to ask yourself is, yes, it's okay. I need to have a project which I would want to give a feel of like a rose flower, whereby, every insect will want to come and settle on. But bankability for me goes beyond the financial attractiveness of a project, the ability to attract. It actually even goes to legal. Because one of the things, if I was actually an investor and I want to invest in a country, I'll be keen to look at is at the 360 feasibility of a project. That's the commercial aspect of it. Who is doing the project? Where is it being done? Who is the off-taker? And how is the tax regime of the country? And do you have the appetite? Do you have the consumers for the product which is being done? That's the commercial aspect of it. But then beyond that, we also have these other things we call the social aspects, and that is the social attractiveness or feasibility of a project, which is the S in an ESG. And what I noted is that when you talk about ESG, we often think about the environmental aspects. We forget about the S and G. Actually, for me, I'll want to accentuate the S to be the E, so that it's SEG. Social one. You do projects for people. Even if I was a commercial person, whichever product I'm giving, the ultimate consumer is the person. Without the person, there's nothing to discuss about. So those are also bankability issues. Then, of course, the governance aspect, which is about how the whole project is going to be run. You know, they are often forgotten. So when you look at ESG, ESG is actually, for me, a 360 view of how projects need to be done. And if you're able to, you know, give meaning to the three letters, then you have a complete bankable project. So the social aspect, you can also bring legal in it, or you can have legal as standalone, but I want to bring the legal within the S. So when you talk about attractiveness of a destination, the legal framework which is in place, or lack of the same matters, because if the legal framework which is in place is enabling, then you make the project bankable and attractive for investment. But if the legal framework is actually unfriendly or is unstable, there is no certainty, then certainly you create room for people not to be willing to come and be investing in that country. So speaking about the principles, the first thing is that if you want to create bankability to projects, then you need to have a legal framework which is attractive for investment. And the other thing we also need to note is that attractiveness does not mean then that the government loses everything, because it's a balance. You can attract, but then you realize the government is getting nothing. So if the government gets nothing, then of course, where is the public interest? It's not there. I'm not saying that the government takes away public interest. The private equally does that. So it's a balance. And if you had to ask me about an ideal legal framework, is that often it must exist. It should take care of the needs of both the investor and the public, and that's what regulators do, in energy, in whichever sector. And the other thing you also need to be keen is that it must be practical, because we've had cases whereby laws are passed, regulations are passed, but in terms of implication or application, it becomes very problematic. There's nothing on the ground. It needs, there's what I call a qualitative aspect of the legal framework. Let it be attractive, let it be implementable, and then let it speak to public participation as well, and let it balance the interest of both parties, and make it easy for compliance. You're getting. So that's one of the things I'll be keen, and even as a regulator, as EPRA, those are the thresholds we use in terms of nurturing the sector, and of course ensuring that the sector remains sustainable. Beyond that, you can also speak about bankability in terms of what the developer needs to do beyond the legal framework and the things which the other party bring on the table. And that's why you can be able to speak about credit enhancement measures, political risk guarantees, things that are getting from MEGA and the sort, all those kind of things. So for me, it's quite holistic. And that's why I began by saying that if today I'm an investor and I want to have identified Kenya as a destination for me, irrespective of the sector, I would actually not want to come to Kenya blindly. I would want to onboard those skill sets which are required to enable me make a holistic decision and at the earliest point possible. I've ever participated in a project whereby I was asking myself, what is this developer trying to do? Because when you try to look at the things which await them, looking at even the tender they've been able to submit, you can clearly tell they did not conceive everything they expect in this country. And it's a case whereby now they come and say, oh, I think you are given the short end of the stick. And that is why projects sometimes don't work, because people don't have a 360 view of the expectations, both from the legal, environmental, social, and social is often forgotten. I think that would be the comment I'll want to give about bankability and creating, stable, certain environment for investment. But quick to note is that stability doesn't mean tying you or tying the government to things which do not allow progress. I'm very passionate about this issue of sustainable development because on one hand, the government has a role to legislate. And it's through legislation that government is able to advance its agenda for social development. At the same time, we have the commercial people. Those are the investors. They want certainty in business. And I've participated in discussions whereby people say that in this contract, you cannot have any change in law absorbed by the investor. It remains with the government. I think the discussion needs to move beyond that, and my understanding is that the government is only limited, or it's only supposed to take charge or take responsibilities for change in law in terms of the monetary aspects in cases whereby the change in law is targeted. If, for example, a change in law is affecting a particular sector like energy, and it's not targeting a particular project, then as a matter of sustainability, that change in law cannot be created in a contract to be taken by the government. Change in law for me means that if there is a targeted, discriminatory, specific change in law to a particular project, then to that extent, the government should retain the obligation to compensate for that change. But if the change is not targeted, it's a general change in law, generally for the whole country or generally for a particular sector, then that change in law is an obligation to be taken by the developer or the investor. So I think that is one of the confusions I usually see people in negotiations, that there's change in law, government. No, it should not work like that. It should be any change in law which is either discriminatory, it's targeted, that is the one which the government needs to chip in by compensating or by making sure then that you are able to take care of that. But not general change in law, because the flip side to that is that you'll be telling the government to forget about legislating or to forget about development. And I know there's a lot of discussion surrounding that, but I will tell you the ideal way, the modern way of structuring those contracts is for the contract to speak to. If there's anything specific, then you need to narrow down to that. But you can't say that a government cannot, have a change in law purely because you want to protect your revenues. And one of the things I will say is that even as you package your project, that is why you need to think about it and factor it as a premium in terms of the consideration they are negotiating with their counterpart.
Okay, so a lot to unpack there. Let's start with the point around risk allocation. Cindy, I'll come back to you on that point, on how you've seen that risk defined in captive power projects where it's not private sector government, it's private sector, which I think the considerations might be a bit different. But I'll start with Lucy on the far end. You've done a comparative analysis of very many jurisdictions in Africa in terms of their compliance requirements. Yeah. CS Kitoo here mentioned that ESG is a lot of aspects, and the social one is usually forgotten. So maybe you can talk about the Kenyan legal aspects in terms of social and governance, and compared to other countries, where do we rank? Where have we gone a step further than our peers, and what can we improve? So I'll start there and then I'll come back to Cindy.
Thanks for the question, Edwin. In terms of the regulatory mapping project, so I can start with a short background. SIA Africa identified a gap. among the developers that were reaching out to them, there seemed to be a lack of understanding or a lack of knowledge on specific aspects of regulatory requirements on environmental and social factors across several markets. So as a result, they commissioned a study across 21 sub-Saharan African countries, essentially to look at 12 factors under both the environment and social pillars. So 12 under environment and I think 11 under social, to see whether local laws provide for these specific factors, and then a step further to look at international frameworks and whether they are ratified for local application in these countries, or whether they are not recognized, and if they are not, are they being implemented? And if they are being implemented, is it because investors require the implementation as part of accessing the financing or unlocking financing, or is it because developers see the need to actually comply on their own, self-reporting? Most of these frameworks can be, especially on the international phase, can be voluntary. So where does Kenya rank? I think we are very advanced in terms of the regulation. So under social, allow me just to mention, under environment, I can mention a few factors that we were looking at. So we have impact assessments, forest conservation, environmental management, dispute resolution on environmental issues. Under social, you have employment and labor relations, things like consumer protection, things like community consent and what the processes are. And for all these different factors I'm mentioning, there's so many, and it's a publicly available website. You can have a look at your own time. The site is called minigridesregulation.africa. Anyway, so across all these factors, we looked at, is there a penalty for non-compliance? What is there a permit required? Is it a consent? Is it an approval, or just a letter of notification to the local authority? Is it at county level, or in countries like DRC, province level, then the national level? What is the timeline within which you can get that permit or consent? Because then you will need to factor that when you're doing the project designing, so that you're able to see how long can you be able to, and then we also categorize them according to different phases of a project. So pre-feasibility, which permits are required under all these factors. During construction, which permits are required, all the way to end of life management, and also fragmented some according that are required across the entire life period of a project. So Kenya is very advanced, and then one of the things to note about Kenya is most of our regulations are publicly available on Kenya law. Our regulatory offices are accessible either online or on call, or you can literally even visit the office to get guidance. In other markets, that's not the case. So in certain instances, only physical applications are required or are available. So you have to physically go to a remote place in certain instances for local governments to be able to get the permits. Then in other instances, they don't have local requirements, and application for international standards is on a voluntary basis.
Yeah, and in Kenya, our regulators also come for panel discussions. Yeah?
Yes.
So Cindy, on that risk allocation point around change in law, could you discuss that for a bit in terms of how nuanced it is when it is two private parties?
Yeah, I think that's quite pertinent. In my mind, Edwin, I had prepared to run through more than just change in law. Like I'd listed down all the risks. Should I limit myself? I will. All right. So as you know, Ibrahim alluded to the fact that change in law, when you have an on-grid project, is typically handled by transferring it to transfer to state, right?
Begs to differ, but I think continue.
Yeah. So here, there are a number of techniques that can be used, because here you're dealing with a developer, the person who actually installs the equipment, and the off-taker, the manufacturer, the power plant, the entity that will use it, right? So the question here is allocating risks between those two, and also factoring in that you may have financiers, right? And financiers are very, very cautious about anything that would mean the project would stall, right? So with that in mind, and then of course we have the EPC contract, which is critical also on that change of law issue. So before, let us assume the developer is also the EPC contractor, which is often the case in captive power projects. Unless specifically mentioned in the EPC contract, that change of law will be borne by the developer. A good example is what we just mentioned about this KEB standard levy. If it is the EPC, if it is the developer who is importing the equipment, and there is no provision that states that in the event of a change in law, the cost will either be negotiated, any cost implication will be negotiated, or attributed to the off-taker to some degree, then the developer will bear that cost. And that was precisely what happened with this KEB standard levy, right? Because most change of law provisions we see in the market have an ambiguous kind of framework that in case of a change in law, then the parties will agree in good faith. That is a wish. It is not something that can protect you. Yeah. And of course, once, these costs materialized, who wants to bear this 10 times cost? At least if you're the off-taker, it would be very foolish to say, yes, pass it to me. Yeah, if the contracts don't already state that. So if you're a developer, please take that into consideration. Another thing to note is that, you see, this KEB standard order is a very good example because it was not an act of parliament. It was an administrative order, right? So in the market, and I come across them day in, day out, change in law provisions are capped to say an act of parliament. We don't specify the full range of subsidiary legislation. So, and even if you state, in lawyer speak, just subsidiary legislation, then now we'd have to define it, right? So all those can be points of dispute, and indeed they were. So right now, the market practice, what we are doing is we're being very rigorous about changing law provisions because we've seen what they can do. We've seen how they can change the cost, the financial modeling of a project. We want to be as thorough as possible. For me, if I'm on the side of the off-taker, then I recognize that the developer may push back. Of course, the developer doesn't want to be the one bearing all these costs, right? Yeah. But it also has, it must make commercial sense. So we are working very closely with off-takers team to make sure the commercial modeling, the financial modeling is something that works. So like if we are to negotiate a floor, then it will not leave either the off-taker or the developer in a situation where the project no longer makes commercial sense to them.
Yeah. These projects are usually long-term and the financials are agreed upfront. So there's a need to allocate those uncertainties in the legal drafting. And I remember in our last session, ChatGPT said that Kenya is very good in terms of progress. We are good in terms of trying out things. So it's a fluid space. I'm sure there are a lot of changes that are coming. There are some that we know about. Maybe to put you again on the spot, CS Kitoo, maybe you can tell us on some of the upcoming regulatory developments that would affect the captive power space. What are they? What would they mean for the sector? And then I'll also ask Edwin, who's also getting too comfortable, to also chip in on what that might mean for the market.
Yeah, thank you, Edwin. I'll say that the discussions we're having here is nothing different from what we'll expect from lawyers in negotiation. So what Cindy is actually saying is what one will do for his or her client. Usually what I'm saying is what one will do for his or her client. So you may need to have that in mind. And I always tell people that if you put in whichever side, I'll be able to argue for my client. So it's good to have that understanding. But the principle number one, which we need to understand, is that It is the business of the government to legislate. It is the business of the government to ensure sustainable development. That's why I've said sustainable, looking at both parties. And you may not get an answer to the question you are asking. The answer lies in the specific projects. Because like Sid was actually saying, he spoke about EPC contract. And in an EPC contract, the question is, who are the parties? So all those dynamics come into play. And that's why I always tell people, listen, but just know that you need to apply what you've been told in light of the specific transaction. But I was just trying to give the principle that the government has a business to legislate, and there's no way you can hamstring the government from ensuring development. Or what you need to make sure is that whatever the government does not unduly, come close to something like impairing your right to economic development and, of course, ability to prosper. Speaking about the same issue, about bankability, there is something we call due diligence. And when you're talking about instances of cases whereby you are afraid of things to do with maybe the government appropriating or intervening in a way which compromises your projections on profitability or remaining a going concern, any prudent investor will want to do due diligence in a country to ask you which laws do exist to protect my investment in the event that something happens and I don't have commercial measures to take care of it. That's why somebody will be able to ask yourself, which bilateral investment treaties maybe does Kenya signed with the country the investment is coming from? Because that is where you'll now get a remedy when the government does things which obviously run foul of international commitments. So it's a whole host of things you need to have in mind before you think of investing, and also to take care of these things we are talking about, change in law. We also talking about things to do with political risk guarantees and the sort. Now, Edwin, speaking about the future outlook of regulating the energy sector and captive, the first thing he says that we are not excited to regulate, especially where things are working well. And what we've done, and I think you've seen it even for captive, is that we've been very slow to intervene. We've actually taken an approach we call sandbox, whereby you allow people to come, they can do their own things for as long as the safety aspect is taken care of. Ours is safety first, it's not money. And that is why, even for captive, I'm very sure people apply for licenses and we don't charge. I may need to bring it to your information that for every application, it goes through 3 steps within the authority: operational level, at the board level, technical, and the full board. Administratively, that means money. But so far, we've not been able to even give a penny to that. It's because we take that approach whereby we allow the sector to spur, to grow. We are not willing to intervene and stifle. But emergingly, once we've been able to see impact and then the concerns start being raised, of course, I said safety we never ignore. We are always regulating for safety. Then that is when now we start coming in, because we also have a good feel of the market and what are the areas we need to regulate. Otherwise, you'll end up having statutes or regulations which are of no effect because they are not, you can't regulate nothing. And I think M-Pesa speaks to that. So yes, we've been slow to regulate captive, but then you and me agree that there are emerging issues which we need to think through, not as a regulator, but in liaison with the stakeholders and the government as a whole, so that then we can be able to ensure then that as you do your business, as you do your C&I business, everybody is safe, the government is equally comfortable with what is happening, because what you do has a way of affecting another person. So there are a lot of discussions within the authority and even with the stakeholders surrounding captives, and this conference is one of them. And of course, I know certainly in the next 1 or 2 years, we are going to have discussions surrounding captive power and regulation. And what I can tell you is that we'll subject it to robust public participation. Your input will be taken into consideration, but equally, our mandate as a regulator will equally be taken into consideration. But there are a lot of discussions, and of course this session is one of them, not only on captive, but generally across several other emerging issues within the sector.
Thank you, CS Kitoo. Yes, I'm being prompted to go into Q&A. Edwin, a few words around what we know are the upcoming regulations around open access, net metering, ETC, and how those might affect the sector.
Yeah, thanks. Excuse me. So with regards to the open access and wheeling basically means that you can put up a solar system not necessarily right next to or on the roof of an existing factory, for example. You can feed it to a substation where it gets fed to your client, and you can work out a system with Kenya Power by which you bill the client. That's a very simplistic way to look at it. What I anticipate is going to happen is, because correct me if I'm wrong, Kitoo, is that initially for the open access, we're looking at 100 megawatts to start, something along those lines. So what that means is that for large players for whom the roof space just is insufficient. If you have 80, 50, 80, 90, 100 megawatts of consumption, you're not going to have enough roof space to do that. You might not be in a place that is conducive to you buying the piece of land right next to your factory to be able to do the installation. So this is going to be very beneficial. And actually, I would like to congratulate the government on getting that one over the line. We've seen it work very well in South Africa, and we expect it's going to work very well here. What do I think is going to happen? How I anticipate that is going to play out is that because of the nature of the scale of the installations, we are going to coalesce around 2 or 3 large players, developers who can afford to finance these kinds of projects. Again, this is the kind of thing that is going to definitely interest players from outside the market, developers to come into the market. And that's one of the reasons I wanted to congratulate them, because this is very forward thinking in terms of attracting capital. The other thing that I think is going to happen is a very Kenya-based thing by which there's going to be a lot of land speculation. If you need to feed into a substation near you, then that means that the pieces of land in the surrounding areas are going to become maguta, as we like to say, yeah? So we also anticipate that there's going to be a micro industry that is going to be formed around the setting up of wheeling conversations and wheeling projects. Yeah, I think that is what I anticipate is going to happen in the near future, or as soon as we have the laws ratified, because we know that they've been sitting somewhere for a long time.
Thank you very much. I think having the laws and having them implemented can sometimes be very separate things. But I think we'll go to the floor now, take a few questions. We have how many minutes? He's saying 20 or 5. Yes, we have 5 minutes of Q&A. So let me just take some few questions quickly, starting there, and then we have a few at the front. Let me take 2 and then we'll come to you in the next round.
Thank you. This is Kaluki. I have a question for the regulator, CS. We agree that the side you're sitting, like you said, you can defend. When they do change of law, they're looking at sustainability. But rooms like this question how fast, how quick, or otherwise the government takes to do such. A case in example, we had the panel of e-mobility earlier in the morning, and we had comparisons of, we are regretting as Kenyans that we were somewhere on the map, but internationally now, Ethiopia is ahead of us. Anyone who's been to Addis in the last 1.5 years, you'll come back to Kenyans and tell them, shut up. These guys are ahead. Until today, the government is still taking sweet time to have that regulation. So, captive is here to stay. I say this is the Uber yellow taxi. And there are so many opportunities for the government to make money. But what they are telling us is you're cannibalizing our sector.
So they will keep saying, they'll keep protecting and defending, Then 5 years down the line, they come and tell us, oh, we have this new regulation. You have to consider it in your contracts. Who is to blame? So yesterday, we had your colleagues here. Engineer Daktari was telling us they're still on the desktop doing research. How long should the citizens give the government to get these regulations in place?
I think you'll have to hire me as your lawyer. Let's take the next question.
My name is Catherine Irura, the MD of Soita Kenya, also Secretary at ESAC and Chairperson of the Green Hydrogen Association. And I want to address this comment also to my senior here, Kitoo, because I'm an advocate also. But we are being pushed for cost-reflective tariffs. There's no way you can internalize a change in future law cost in your financial model. Tariffs, there's a push to lower generation tariffs, all these pass-through costs. Everyone is trying to reduce the cost of power. There's no way it can be, in my view, internalized in a financial model. And most companies are affected by these changes in law in terms of their operational costs. You've seen over the past few years how tax has really changed on the wage bills. And this new levy, she talked about the KEBS levy and WARMA levy. They're somehow supposed to be internalized by a business and you operate as a loss. In other sectors outside of energy, we have seen companies leaving the country, layoffs of staff. People I personally know who have worked in companies that have been in existence in Kenya since the 1900s. So we need to think about what you said, the sustainability of the sector, not just legislate and increase OPEX, but look at how is this affecting the sales of the products in the market? How will it affect the affordability of the power? That would be my input. And these financial models, we share them when we are applying for licenses. So you have visibility. We're the most, as you said, regulated sector. So we really need the executive, even parliamentarians to have that view, look at the entire value chain, because you can't be pitching for more jobs, more industrial growth, and then you're stifling growth in a way through high operational costs.
I'll let Kitoo respond.
So that I don't lose track for the questions.
Can I ask so that you respond everything?
Okay, if they are closely connected, yes.
Yes, I think they are closely connected. I want to look at the regional. Sorry, my name is James Ngomeli. You have a regional organization of regulators. How is it working to harmonize? Because we are having very big challenges. For example, the Zambia, how they do it and how you regulate here. Is that association really, what is the role of that association? And if you feel kuna kitu inakufinya, can you address it to that regional association so it can address the other factors, your members? I think that's give us the role of that association. Secondly, I'm looking at the oil and gas sector. I think you sit on that. How do you think it can accelerate C&I projects in the region? Thank you.
You know, if I was an accused and I have my lawyer here, Cindy, I would have said that the more the questions you ask, the more unjust you become to the accused. So it's called the compounding effect of many questions. But I'll attempt to answer some of these questions. Let me speak for myself first, even before I speak for the government. Passionately, I'm very passionate about energy access. And I say, there's no access. You can't talk about access if there's no affordability. You get? The affordability aspect is an enabler to the access. So as a regulator, and just also speaking for the government, because we enable the government to meet its mandate, our critical role, and that's what we call regulator, is to ensure that word sustainability. And this is where the whole problem is, because you have a case whereby we have two competing interests. We have the investor, and then of course we have the consumers. Each one of them, if you are to ask the consumer, they will want to tell you that they want power free. If you are to ask the investor, they want to get everything. And I always say that if today you want to have a cat in a house, you cannot afford to skin it. So that calls for balance. So as a regulator, speaking as a regulator, not government, because government is big, our role is to ensure that there is that balance. In fact, often we have very difficult conversations with the government itself. And that tells you how independent we are. Now, trying to answer the question of captive. Kaluki, I will tell you that as late as yesterday and for the last 6 months, the issue of captive has been a running theme within the regulator. To an extent that me as a CS, it is always a standing agenda in the board, because we are always having and we want to have closure on that issue. But as you want to have closure on that issue, and speaking to the timelines you are talking about, our constitution is our biggest strength. It is equally our weakness, to the extent that it calls for public participation, which even as we speak right now, it has not been defined, even by the Supreme Court, or we do not have any laws speaking to that. So we talk about public participation. It is as good as you, Edwin, Georgia. So that is one of the biggest challenges, but I will say it is also the biggest strength we have as a country. So what we are trying to do, and to speak to the qualitative aspect, is that yes, we want to churn regulations, but we want to churn regulations which balance all these interests, and whereby each body, each person feels like they have been heard and their opinion counted, even if it's not mainstreamed within the regulations. So that's the nature of our constitution. That's the nature of the country we are in. And I'm also sitting at a point whereby I defend so many cases, and I'm proud to say that because of the robust nature of our process, our win for cases is almost 98%, because we ensure that we tick the box and we just don't deliver regulations, but we ensure that we are doing things which are sustainable. So it's a challenge, and I take it up. And as a regulator, we have actually taken that challenge, that captive, it is time now to discuss about captive. And as much as we want to discuss it, we don't want to do it in a way in which we end up being in court, or perhaps the parties are not happy. So we are looking at that sustainability. Speaking about cost-reflective tariffs, equally the same thing, balance. You are looking for, in fact, I have an issue with this word cost-reflective, because to anybody who is reading it literally, it speaks about the investor alone. So as a regulator, our role is to, yes, when you talk about, cost reflective, if you're just looking at it, without looking at the whole act, then somebody can say that we only regulate and we're only taking care of the interest of the investors. No. Our understanding of cost reflective means that we take care of your costs, but equally, and we ensure that, of course, we have some premium, but equally we take care of the consumer aspects, consumer needs. That is just and reasonable, and that's why our test for cost is they must be prudent, they must be reasonable, as much as possible they must be provable. I will tell you today, if you are to bring a PPA or any request for tariff, that is the rigor we take it through, and we are taking through, including the just about to be brought request for tariff review by Kenya Power. So we are agile, we are robust, and we are equally enabled. And I think we are not going to do injustice to Kenyans. We are going to make sure that everybody is able to be happy, and we sustain the sector. On the question of harmony and what the regional body is doing, it's called EPRA. So EPRA is an association of energy regulators. So it's a body which looks into the concerns of all the regulators and, of course, all the countries which are parties to. So area is very robust. There are a lot of discussions happening, but I think Gomeli, I'll agree that there's a lot which needs to be done by area. But before we fix area, we are fixing the nation first. So we are more focused on sorting Kenya and Kenyan issues before we talk about the regional issues. That is not to undermine the fact that we've gone regional, and that's why we are even approving, cross power exchange agreements. I think for the last 3 years we've done at least 2, and that is where the country is moving. But my parting shot will be, we are on guard to take care of public interest vis-a-vis investor interest for sustainable regulation of the sector.
Yeah, I think, thank you very much. Standing between you and your lunch. So I'll just close this panel and I'll ask everyone to give our panelists a big hearty clap.